webcast. I'd also like to thank Commissioners Dunn, Summers, Commissioner Chilton, Commissioner Amalia for their significant contributions to the rule writing process, and I'd like to thank the hardworking staff of the CFTC who have been working day and many a night and weekend to bring these rules and recommendations before us. During today's meeting, the Commission will consider two proposed rules regarding implementation schedule for swap transaction compliance. We also will consider an International Organization of Securities Commissioners report, what many people call IOSCO, on the principles of regulation and supervision of commodity derivatives markets. This week, I think it's appropriate for us to remember September 11th, 2001. 10 years ago, the CFTC's New York office was on the 37th floor of the World Trade Center's North Tower. And that morning, 56 members of the CFTC staff were in harm's way when the planes hit the towers. Thankfully, each of the members of our staff made it out of the area safely, but far too many people did not. And we will all take a moment on Sunday to remember the fallen and to praise the heroes who saved lives. The response from the other CFTC offices, as well as our New York office, was to rally around all of our colleagues in the aftermath of that attack. Many of the staff members from New York still work for the CFTC. And remarkably, the CFTC seal from the North Tower was actually recovered at Ground Zero in 2002 and now is displayed in our New York office. We also commend our many friends in the New York futures industry, which was deeply affected by the attacks. Through devastation and personal losses, the industry worked together night and day to quickly restore market operations. Today is our 19th open meeting on Dodd-Frank rules. We largely completed our proposal phase this spring, and the CFTC's first step, really, in implementing financial reform. This summer, the Commission turned to an important corner, the second major step, really, turning towards final rules to make the swaps marketplace more transparent for participants and safer for taxpayers. And to date, we've finished, I believe it's 12 final rules, and we have a full schedule of meetings in front of us. The rules we'll consider today are about the timing for compliance with new rules. Compliance, in essence, represents the third major step. Once rules are in place, what's the implementation and compliance schedules to make financial reform a reality and to protect the American public. I'd like to take a moment to discuss what we may consider between now and the end of the year on Title VII, and some of those rules that we may more likely take up after the new year. A more complete list will be available on our website, but let me start by just focusing on some of these rules. And we're going to consider rules thoughtfully. We're not going to do it against a clock. No doubt this is a human endeavor, and there will likely to be many changes of any outline down the road. And we'll continue to reach out broadly to other regulators, both here and abroad, for their input as we consider the many thousands of comments that we've received. The next two items on our queue for the CFTC to consider are rules related to clearinghouses, core principles, and position limits. In the last quarter of 2011, we're also hope to consider final rules on entity and product definitions, both of which are joint rules with the SEC. So it's a lot for two commissions to lock arms and bring together, but important underlying for many of our other rules. In addition, we hope to consider final rules on swap data record keeping and reporting, real-time reporting, and regulations related to trading platforms called designated contract markets or exchanges and foreign boards of trade. All of these rules, once considered, will help the swap markets to be more open and transparent. And we're looking at considering external business conduct and internal business conduct. This is, in essence, how the swap dealers themselves manage their risk and supervision and conflicts, but also how they relate directly to the public. And we anticipate seeking public input on the application of something called Section 722D of Dodd-Frank. This relates to which transactions come within the jurisdiction. Sometimes people call it extraterritoriality. Now, much like we did on July 14th of this year, I think this fall we will also consider further exemptive relief from the application of Dodd-Frank's Title VII requirements. And I've already directed staff to draft recommendations with relief appropriately tailored. For instance, if we complete product definitions, further defining the term swap dealer, for instance, or further defining the term swap, the exemptive relief might take on a little bit different form or words than it did in July. But I've already directed staff so that market participants could have that clarity and that confidence going into later this year. Let me also highlight some of the rules that we expect will be taken up after the first of the year. As part of the effort to make the swaps market more open and transparent, I would anticipate we'll turn to the final rules on swap execution facilities, but probably not before the end of the year. The agency has been working also very closely with other regulators here and abroad on capital and margin rules, but as they were proposed later in the time frame, I'd expect those two to be after the first of the year, and right now looking towards the first quarter. We also would look to finalize rules on documentation and something called straight-through processing and other client clearing issues, some of the segregation rules. Again, a more detailed list will be available on our website, and this is really just a tentative outline to give market participants a better sense of how this might unfold. In addition, I'd like to take a moment to talk about the process for clearing mandate determinations. In July, the CFTC finalized a rule on the process for review of swaps for mandatory clearing, and it will be effective on September 26th of this year. Under this congressionally mandated process, the Commission has 90 days to review a clearinghouse's submission and determine whether the swap is required to be cleared. And though much of the timing will actually be decided by the clearinghouses, they need to come to us and make some submission to us, it's likely that they will not begin to file submissions until later this fall, until we do more rule writing. But of course, it's up to the clearinghouses. And they might not even come to us this fall, that it's more likely they'd come to us in the winter after various rules that we consider are finalized. Once these submissions come in, the Commission staff will begin to process them, and as I said, the Congress gave us 90 days to process them. And so, though it's quite up to the clearinghouses when they make the submissions, I would anticipate we wouldn't be, as a Commission, looking to do clearing determinations until, of course, into 2012, and more likely at the earliest at the end of the first quarter or into the second quarter of 2012. Now, how does that all fit into today and what we're doing today? I want to turn to implementation phasing. Implementation phasing really relates to the third key area for us after we finalize the rules. Really, how does the market comply with those rules? The timeline by which various market participants bring their swap transactions into compliance with the new requirements, including mandatory clearing and trading, as well as swap documentation and margining. Recognizing that some market participants may require more time than others to comply, these proposed rules are part of our effort to help ensure there's adequate time to plan for oversight of the swaps market. And the staff reached out broadly on the topic, including 2 public roundtables with the SEC in May. We also invited comments to our website on implementation phasing, and have been fortunate that market participants have participated in dozens of meetings with staff and commissioners, and the comments have been very constructive. The first rule proposed a schedule for phasing compliance with swap clearing and trading. market participants would be required to comply with the Commission-issued clearing mandate, but no sooner than a phasing of 3 months, 6 months, or 9 months, depending upon the swap's counterparties. The statute actually would allow us to do it earlier, so this is a form of relief in essence. But this timeline would begin only after the mandatory clearing determination, which I just discussed, and it was at least my anticipation, and I can't speak for the clearinghouses, but it's my anticipation that that determination is probably at least 6 months away, if not longer, depending upon when the clearinghouses come and knock on our doors this fall or winter. In addition, the proposal states that no market participant would be required to comply with the clearing mandate before the Commission finalizes certain key rules. In essence, until we finalize further defining swaps, further defining swap dealer, and some key rules with regard to segregation, if I recall. So market participants will have time to make plans for compliance. Of course, we're going to seek public comment on this, but it's just a proposal. But the idea is really to phase this and allow market participants time to make the planning of the back office and their documentation and so forth. In terms of the trading requirement, market participants would have at least 30 days after the swap became available for trading on the facility or the contract market or swap execution facility brought the trading requirement forward. The second proposal is an implementation schedule for trading documentation and margin requirements. Again, as I said earlier, I think we will not take up those final rules until after the first of the year, final rules with regard to documentation and margin requirements. But today we are sort of, I guess it's further proposing, if I have the technical term right, those rules to get input on compliance. And again, this compliance schedule would apply to swap dealers and major swap participants that have to come under the documentation rules, but would give 3 months, 6 months, and 9 months compliance schedule again for their counterparties. And as we're not going to be taking those rules up probably in final form for a number of months, this is really, again, a phasing throughout 2012 potentially. The Commission is seeking public input on these proposed rules, which apply to the core areas of Dodd-Frank reform. They're designed to smooth the transition from unregulated market structure to a safer market structure. And more information regarding the proposals will be available in fact sheets and Q&As and, of course, the documents themselves. What we're considering today are not the only opportunities that the Commission will have to phase implementation of final rules. As we progress on each of the major rules, we'll be continuing to look at appropriate timing for compliance. Sometimes it's a compliance for the clearinghouse itself, as opposed to market participants more broadly, or for the swap execution facility itself. And each time we'll be balancing the desire to protect the public while providing adequate time for industry to comply with these new rules. When all of our Dodd-Frank rules are completed, I believe that it is appropriate that the Commission take a step back at the right time in the future. It might not be immediate, but to take a step back the right time in the future and carefully evaluate the new regulatory landscape as a whole and how it is actually working. This is another part of our efforts to thoughtfully implement the reforms in the Dodd-Frank Act. But until the CFTC completes its rule writing process and implements and enforces these rules, the public does remain unprotected from Congress's broad reforms. That's why the CFTC is working so hard to ensure that the swaps market reform promotes more open and transparent market, lowers cost for companies and their customers, and protects taxpayers. So I went a little longer here today than I normally did, but I wanted to go through some of the thinking on the schedule. Certainly if other commissioners have questions for me, I'll even take them because we're allowed to deliberate. But I think we'll lay out on our website some of these initial thoughts. We have a lot in front of us. We're not doing this against a clock. We're going to get each of these in a balanced way and taking in consideration all the comments that are before us. So with that, I was going to turn to my fellow commissioners.
Thank you, Mr. Chairman. I want to thank everyone for joining us today at this important meeting. And today we will consider the IOSCO report for principles for the regulations and supervisions of commodity derivatives markets. Over the past few years, and particularly in the aftermath of the financial crisis of 2008, it has been clear to all of us that what we do here in the U.S. affects markets around the world. Similarly, actions taken around the world affects the markets here. This global interdependency places responsibility on regulators to not only understand what the impact of our actions will be in our markets, but also what the global impacts of our actions will be. Global interdependency also requires us to be aware of how to protect our markets from the negative impacts of action taken in other financial markets. I have for some time emphasized the need for world regulatory bodies to work in harmony to prevent a future financial crisis, and if another crisis should occur, to face it on a global playing field. I think, Mr. Chairman, the actions taken by the G20 and delegation to the FSB of coming up with principles and the subsequent work on IOSCO of developing principles is the best we can do internationally for beginning to look at the harmonization together. And I really commend our staff and the staff of IOSCO of putting together these principles. The report we consider today presents an important first step towards this harmonization. The IOSCO report establishes international accepted principles for the regulation and supervision of commodity derivatives market. It is my sincere hope that the principles established in the report will lead to meaningful and consistent financial regulatory oversight and global scale. Now, Mr. Chairman, if we can have a done set, I think we can have an O'Malley mark as well. And the other things we will be considering today, I consider the O'Malley mark. He has been tenacious in trying to get us to do scheduling so that everyone can take a look at what we're going to be doing. And in listening to your opening statements, I was reminded of the old Rube Goldberg cartoons. Now, for anybody that's under 50, Rube Goldberg was an artist that used to draw out these very elaborate sketches of how things act. The rooster will crow in the morning. That'll startle the cat. The cat will jump. The shade will go up. That'll startle the parrot. The parrot will fly off. That'll pull the string, and the marble will start down. It'll start the coffee. It click the coffee maker. Click the oven. Turn the oven on and set off the alarm to wake the person up to go to work. That's kind of what we're doing right here. We're looking at all of these things that have to take place in some kind of sequence to get to where we are at the end of the day of providing greater protection for not only the United States public, but the world in the financial industries. And the two proposals we're doing today on the implementation of compliance dates for final rules that are related to Dodd-Frank really tells the world what has to take place, where we're going to be, and when do we think these are going to have to take place. Mr. Chairman, I really commend you on getting public comments during the implementation phasing. It's going to be extremely useful. On May 2nd and 3rd, the CFTC and SEC, as you had said, held a joint roundtable meeting on issues related to implementation. The staff proposed 13 concepts to be considered, and the staff asked questions to be based on the concepts that were outlined. In addition, the Commission reopened the comment period on many of the proposed rules until June 3rd in order to allow comments from the public regarding the entire mosaic of rules. The comments made at the roundtable and the comments letters from various market participants and the public raised key themes that shapes today's proposed rules. While I understand that there are some who would like even greater clarity regarding the timing of implementation, and I welcome the public's comments on suggestions during the comment period, and I believe the proposed rules provide clarity for the industry while simultaneously providing the Commission with the flexibility and information it needs to fashion effective final rules. Mr. Chairman, as you pointed out, we're probably not going to get this entirely right. But the public, the industry, is going to have a number of bites of the apple. If we do a rule that is so wrong, we're going to get flooded with comments immediately on it. And I think we're prudent people. We'll react. We'll change it. If we have got it, if we're landing the airplane upside down, we're going to flip it over. We're going to try to get it right. But regardless of us taking immediate action, if we've got some unintended consequence that's going to be out there, folks have the opportunity to go to Congress and change the law, which is what we are implementing. They have the opportunity to go to court to challenge us as to whether or not we have the authority to do what we're going to do. They have the opportunity under the Administrative Procedure Act to petition us to change that regulation. And for us to take a look at it after the fact to establish the efficacy of that rule, I think is an excellent idea. I'd like to see us do it within a 12 to 18-month period if we have the luxury of resources to be able to do that. Now, as I said that, I noticed that a lot of the lobbyists and law firms out there are smiling because this is a great cottage industry for them with all of those opportunities that they're going to have to ensure that we get it right. But it is important that we get it right. And again, Mr. Chairman, I want to thank you and the staff for going that extra mile to try to get as much input as we can up front so we don't have to go back and rewrite all of those regulations. I also like to thank the staff that worked on these proposals that we have today. I appreciate the hard work that you put in, and I see that Gary is out there. Burnett, this is his first opportunity for us to cross-examining and grill him, and we've got lots of questions, Gary. We'll get you on that. But again, Mr. Chairman, thank you for providing this opportunity today.
Thank you, Commissioner Dunn. Commissioner Summers.
Good morning. Thank you, Mr. Chairman, and thank you to all the teams that have worked very hard to have these proposals before us today. The implementation proposals, as well as to the Office of International Affairs for their hard work on the IOSCO principles for the regulation and supervision of the commodity derivatives markets. I appreciate all of the efforts that you all go to, the long hours that you spend, and I think we all appreciate what you go through to have the proposals in the shape that they are to have before us today. So thank you all. The IOSCO Commodity Markets Task Force was created in 2008 and is co-chaired by the CFTC. Since 2008, our staff has done an outstanding job of identifying issues, working with industry, and highlighting inconsistencies with our fellow regulators. International coordination of regulations and regulatory objectives is critical as we move forward. Without coordinated and consistent international regulatory approaches, we run the risk of doing great damage to U.S. futures, option, and swaps markets. The report goes a long way to avoid such an outcome. As I have said many times, finalizing the complex rule proposals before us will be a challenge. I have advocated that the Commission inform the public of the order in which we plan to sequence the consideration of final rules and publish a detailed implementation plan. I'm pleased that the Commission is posting an outline of its final rule planning through the end of the first quarter of 2012. This is a helpful first step that gives market participants a view into which final rules the Commission expects to consider in the fourth quarter of 2011 and in the first quarter of 2012. I'm hopeful that we will have a more detailed plan that we can publish in the near future. This would be helpful for us and for those who are trying to tailor their business plans and are concerned about being in compliance with the new structure. Regarding the two implementation proposals before us, I reluctantly support both of them. I support them because they give market participants some certainty about implementation deadlines. My reluctance stems from my view that these proposals represent a very narrow portion of what I expected to be in an implementation plan. I believe we should have taken this opportunity to attempt to present a comprehensive plan and seek public comment on it. After all, 4 months ago, we held a 2-day roundtable on implementation issues, proposed 13 concepts to be considered regarding implementation phasing, and asked a series of questions based on those concepts. Those 13 concepts included issues such as market infrastructure, real-time reporting issues, which we have chosen not to include today. Establishing an implementation and compliance schedule for all of the Dodd-Frank final rules will be very complicated, and it will be based on a series of assumptions about how swap markets operate and how they will evolve. Now is the time for us to attempt to craft a bold and comprehensive plan for public comment. The Commission and the public can only benefit from publicly engaging in that exercise and from challenging our assumptions and our approach to substantially increasing the regulatory oversight of futures options and swap markets. I hope that we will take advantage of that opportunity. The process of considering these two proposals have made it clear to me that over the last year, the Commission has failed to address a critical component of the trade execution requirement in Section 2H8 of the Commodity Exchange Act. That is, what does it mean to make a swap available to trade? Once the Commission determines that a swap must be cleared, all non-end users must execute that swap on a DCM or CEF, unless no DCM or CEF makes the swap available to trade. This is a very important provision because if a DCM or CEF makes the swap available to trade, a non-end user participant that enters into a swap bilaterally will be violating the CEA and will be subject to an enforcement action. In other sections of the CEA, Congress used the phrases list for trading and listing for trading. By using the phrase makes available for trading in Section 2H8, Congress must have meant something different than list or listing for trading. Unfortunately, our DCM proposal was completely silent on the matter, and our CEF proposal was ambiguous at best. The trade execution requirement is a critical component of the new regulatory regime. Allowing an exception to the trade execution requirement to remain vague and undefined, or worse yet, defined on an ad hoc basis by market participants, would be irresponsible. I believe the Commission should clarify who makes the determination, the Commission should clarify who makes the determination that a swap is made available for trading and define how that decision will be made. Before concluding my remarks, I must point out that since the Grain Futures Act of 1922, Congress has recognized the importance of maintaining the confidentiality of trader positions. The recent release of protected Section 8 material is a serious breach that could undermine the integrity of our markets and our ability to work closely with our international counterparts. I am disappointed that in the face of such a serious breach, this Commission has remained silent. In 1947, the Secretary of Agriculture refused to disclose to Congress trader names and positions without a request from Congress in the form of a joint resolution. In 1975, the CFTC issued a policy statement that insisted that prior to complying with a congressional request for confidential position information, the request must be put to a vote of the relevant congressional committee. I understand that the law requires us to furnish this kind of information to committees of jurisdiction, but I believe the time has come for this Commission to establish a process to better protect confidential Section 8 material. Thank you again to the teams that are before us today, and I look forward to asking questions about the proposals. Thank you.
Thank you, Commissioner Summers, on all that you said, but I thank you particularly for that last bit. I think it is important for markets to know that this Commission complies with the law, and the law is very clear, as you say, for decades about protecting confidential information, that this commission protect that information. So I look forward to working with all the commissioners on that matter. Commissioner Chilton.
Thanks, Mr. Chairman. Commissioner Summers always raises some good points. And all of a sudden, I know what I'm going to say, and I want to change it, and so that's good, though. I support the proposals today. Thank you for all your hard work on those, and look forward to moving forward on them. I also support the IOSCO principles for the reasons that both Commissioner Dunn and Commissioner Summers talked about. We've sort of been the leaders on these issues, although the EU's moving forward, as everybody knows. But I think approving these principles sort of should allay some of the fears about regulatory arbitrage, that we are generally moving forward together. So I'm very pleased. It's important. I thank our International Affairs Division for working on it, and thank the IOSCO staff. On the Section 8 stuff, I agree with the concerns about having information that we are to protect getting out. And I understand how that can, one, it's against the law for us to give it out, so there's no question about that. I don't believe we've done anything inappropriate. We gave it to a congressional committee of jurisdiction. After that, once it gets to Capitol Hill, that's an issue for Congress to deal with. We've abided by the law as far as I know. And I do think it's important to protect confidentiality. I will say that, 3-year-old information that gets out there, I'm not sure there's any top secret, trade secrets that are in that information. I'm not saying that it's right to have it out there, but there is some time in the future where, information as a policy question, not as a matter of law now, law is clear now, but it's a policy question. It seems to me there's some point at which the data getting out there shouldn't drive everybody nuts, and I think there's a little bit of, the sky's falling, and I'm not saying that it was right to have the information out there, but I think there's some place in the middle here for a policy discussion later. But I agree with the concerns that Commissioner Summers raised and the Chairman echoed. On the suggested time frame, I really commend you, Mr. Chairman, for coming up with this and for being prompted by my colleagues. I think all of us at one point said it would be a good thing to do, and I appreciate you doing that. There's certainly things I would have liked to have seen done earlier. I won't get into those now, position limits. But by and large, I think we've gone forward on these things in a really judicious manner. And I think they're having the added benefit. I talked about it when we did the SDR rule and the ag swaps rule. We're actually helping to create a system that will sort of fuel inject the economic engine of our democracy. I mean, government doesn't create the jobs, but we're establishing sort of a whole new structure. I mean, if you think about it, security markets and exchanges existed, commodity markets and exchanges existed, and then they were regulated. The OTC market exists, but there's no exchange, there's no sideboards on it. That's part of the problem that we got into, the country got into, the economy got into. So we've got a real opportunity here, and I think if we think sort of unconventionally, we actually can help do some real good here, create jobs, help to create jobs. Government doesn't create jobs, help to create jobs. So I thank you for that, Mr. Chairman. And look, you'll get criticized from one side and then the other, and it won't be, you're going too slow, you're going too fast, it's not detailed enough, and some of them, may have some merit. But by and large, what my experience in Washington has been, when you're getting hit from both sides a little bit, in the middle, you're probably doing something right. So thank you for your leadership in doing what I think is something right.
Thank you, Commissioner Chilton, for all your support. And I did say that the next thing on the queue is clearinghouse and position limits. And
booyah.
I mean, as all of you know, I mean, we're all weighing in now on these documents that are in front of the commissioners and their legal assistants. So I thank you for all your input on all those rules. Commissioner Amalia.
Mr. Chairman, let me begin by thanking you specifically for this hearing. This isn't a Dodd-Frank rulemaking. This isn't a Section 731 or 732 or any of the 7 series rules. This is completely out of whole cloth, and this is certainly because you put the team together and asked them to put 4 rules together and give some clarity. So I greatly appreciate that, and I think you've really tried to bring some more clarity to the situation. These 2 implementation proposals aim to provide greater certainty to the market as to when the Commission will impose the clearing and trading mandates, as well as when the Commission will require compliance with certain documentation and margin rules. Without a doubt, these are 4 very critical rules. I'm grateful that the Commission is providing more certainty in this regard, and the willingness to provide a general outline of the rules that we will be considering over the next 2 quarters is especially helpful. I know you will not be surprised to hear that I intend to press for further clarity on the order of the rulemakings and a schedule for implementation of the over 50 rulemakings that were not included in this document. Slowly, the rulemaking process is coming into focus. The reality is the rulemaking process is on track to comply with the G20 directive of mandatory clearing by the end of 2012. Frankly, I would say the clearing mandate is likely to kick in around the 3rd quarter of 2012. But that's just a guess because there are so many remaining variables. And I appreciate the challenge that you have to keep us on track to narrow those down. Despite the Commission's efforts here today, I fear the market will find these proposals raise more questions than they answer. They fail to facilitate a transition to the new regulatory regime in an orderly manner that the market as well as the Commission desires. Rather than defining what we know, these proposals emphasize what we don't know about the implementation plan. I would like to highlight 6 areas where additional guidance would be beneficial so that the market participants could begin to allocate resources and begin compliance in an accelerated manner. First, a proposal for the clearing and trading mandates may not apply in certain situations. The proposal states on page 22, quote, when issuing a mandatory clearing determination, the Commission would set an effective date by which all market participants would have to comply, end quote. In other words, the proposed compliance schedules would only be used when the Commission believes phasing is necessary based on the consideration outlined in this release. Therefore, despite the proposal, market participants will need to look at each individual mandatory clearing and determination to ascertain whether this specified phasing would apply. To date, the Commission nor the staff has issued any guidance on the substantive criteria that will be used to make a mandatory clearing determination, including any criteria relating to when the determination would become effective. Second, neither proposal provides market participants with beginning or end dates. The proposal for the clearing and trading mandates approximately states the Commission must finalize no less than 5 rulemakings before it can trigger a specified phasing schedule. Third, the proposal only addresses a handful of requirements that the market participants would need to comply with when the Commission finalizes all of the Dodd-Frank rulemakings. Fourth, the proposals do not make it clear when the Commission has decided why the Commission has decided to phase the implementation on a 90, 180, and 270-day timeframes. In fact, several participants in the May 4th implementation roundtable sought longer timeframes to accommodate, among other things, documentation requirements. For example, the Managed Funds Association proposed 120, 210, and 270 tiered approach, which is obviously very similar, just on some different dates.
I'm sorry, Commissioner Mack, can I ask you, what was MFA's numbers again?
120, 210, and 270.
Thanks.
What I'm looking for in this rulemaking is a justification why we chose our numbers over why we chose their numbers. They obviously, through our comment and discussion, we had the benefit of reviewing those and looking into those. So what are the ramifications, why we chose our numbers? I don't find it in our proposal. Fifth, the proposals incorporate an incomplete and inadequate cost-benefit analysis. The proposal boldly and oddly characterizes themselves as relief from timeframes in other proposals or in determinations that Commission has not yet made. With respect to market-wide obligations, such as clearing and trading mandates, we know that the technology investments required for implementation will be massive. New clearing and trading entities, as well as data repositories, all need to be connected to each other and to the firms. In developing back-office systems alone, the TAB Group estimated that the industry would spend in 2011 over $3.4 billion globally and $1 billion in the U.S. alone. With respect to entity-specific obligations, firms will have to make large investments in new software to manage new margin requirements, price aggregation systems, and risk management systems. Knowing when and how the markets are required to deploy these systems is vital to the success of implementing the new market infrastructures required under Dodd-Frank. When billions of dollars are at stake, you simply do not rely on guesses and estimates based on vague conditions. Finally, on a more substantive note, the rules discusses issues as what is meant by made available for trading, which I think Commissioner Summers explained quite well. It is clear that the Commission has not been able to communicate what this standard means. Instead of signaling what we need to address, the Commission is silent. Similarly, instead of making it clear that the Commission will publish guidance on mandatory clearing determinations, it is still unclear how that process will work. The rule proposal also fails to ask some important questions, like how the Commission proposed implementation requirements will affect entities and transactions located outside the United States. I want to be clear, I support completing final rulemaking in a reasonable time frame. I am mindful the industry will need to do the real work to implement the regulatory jargon in the Federal Register that constitute our rulemaking. If we want to promote timely implementation, we need to tell the industry when it will be expected to do so, in what turn, and it can make in what process to make the costly investments in technology and staff that will be necessary to implement the rules we're advocating. Now I'd like to turn to the other agenda item that is not on the Dodd-Frank rulemaking as well, but it illustrates certain themes that the Commission has not adequately addressed in a cohesive manner, is international coordination and extraterritoriality. I have no complaints or issues with the proposal. The IOSCO team did a good job of identifying the principles, international work. I commend their effort and our team specifically for their work. The fact is, with every rule we develop, it raises new questions about how our rules will be harmonized with other global regulators. I've asked for this meeting on the topic to initiate a discussion on our international coordination. International coordination is becoming clear that the schedule for financial reform is converging among the G20 nations and the G20 clearing mandate. It is less clear that the substantive policies underlining the financial reform is experiencing the same convergence. In fact, the fact that may have competitive implications the Commission has yet to fully examine. The IOSCO principles illustrate some of the tensions surrounding the international coordination that we have all seen and will continue to see with respect to Dodd-Frank. For example, while each IOSCO member supports the organization's general principles, each member may have a wildly different interpretation of exactly the regulations would accord under these principles. As we all know, the Commission has set forth a position limits proposals. Regulators in other jurisdictions may set forth dramatically different proposals and still comport with the IOSCO principle. How the Commission plans to manage international regulatory arbitrage and how the Commission intends to enforce that plan remains to be seen. Second, on extraterritoriality, in order for the Commission to coordinate internationally, other regulators should ideally have an understanding of the manner in which the Commission perceives its boundary of its jurisdiction, even if those regulators do not agree with them. I would urge the Commission to make its thoughts on extraterritoriality known sooner rather than later. I would strongly urge the Commission to take a more comprehensive approach in this area, an approach that is coordinated with the SEC and that is chosen with respect to these proposals on compliance before us. Finally, on technology, to comport with the IOSCO principles, the Commission needs to invest more than the minimum in technology. Only by investing more can we achieve the goals of real-time surveillance. Having position management powers means very little if the Commission lacks the tools to exercise those powers. Therefore, I'm going to close by urging the Commission, as I've done many times in the past, to focus on improving its technological capabilities. Mr. Chairman, again, let me thank you for developing this implementation plan. I'm absolutely convinced that we can improve compliance with our rules if we provide much more certainty to the timetables going forward. And I will also be submitting several questions for the record that were not included in this document, but I will include them as part of the record going forward. Thank you.
Thank you, Commissioner O'Malley. the staff will now make presentations concerning their recommendations on the proposals implementing Dodd-Frank Act, as well as the IOSCO report. Though I didn't say something in my opening remarks, Jackie, I'm going to speak to your. I thought I had enough on the other things, but I support that report that you're going to talk about. After each presentation, the floor will be open for questions and comments from the commissioners. Following those discussions, the commission will take votes on the recommendations. To that end, I ask unanimous consent that all final votes conducted in this public meeting of the commission be recorded votes, and that the results of those votes, I'm talking about the unanimous consent on the Dodd-Frank pieces of it, be put in the Federal Register release. Without objection, so be it. Let me introduce Gary Barnett, who's at the table. It just happened to be you sat left, Gary, who recently joined us and will head up as director of the Division of Swap Dealer and Intermediary Oversight, which I guess stands up on October 9th.
That's right.
The new division will be an integral part of implementing Dodd-Frank provisions that will lower risk to the swaps market, to the overall economy. One of the key pieces of Dodd-Frank was the regulation of swap dealers for the first time, and it's historic, and we thought it was appropriate to take this opportunity to take some of the excellent people that are already working on intermediary oversight, overseeing futures commission merchants and commodity pool operators, commodity trading advisors, and stand that up as a division to include in that also the responsibility to see these major intermediaries called swap dealers. They will be working very closely with the NFA, the National Futures Association, in that world. But we thank you, Gary, for leaving a career somewhere else and joining us here.
Thank you.
In addition, this week, John Rogers, and I don't know if John's actually in the room, but I'm just going to give a shout out to John, was promoted to lead the new Office and Data Technology that for the first time will include Data Office, and we are doing some reorganization to move data over into there and to have it report directly to the chairman. And I thank Commissioner Amaya for a lot of your leadership of the Technology Advisory Committee, but also the vision and the sometimes good repartee back and forth about technology. But I think moving data and technology into a full division, and this promotion of John is an excellent move forward that all 5 commissioners supported with the strategic plan earlier this year, and particularly given the wealth of data that's going to be coming into this agency in the swaps world and aggregating it with the futures world and the like. Both of these will be up and running next month and are crucial components to the agency's restructuring and fulfilling and expanding our responsibilities under Dodd-Frank, and will help provide necessary oversight for the futures and swaps markets. So having made that shout out at this time, I guess Deval Patel and Mark Higgins have been our respective team leads. Dan Berkovitz from the Office of General Counsel, along with Ananda Radhakrishnan, and from the Division of Clearing and Intermediary Oversight, and Rick Schiltz from the Division of Market Oversight, joined by their new division head, will present their recommendations and the consideration of these 2 notices, and then we'll figure out how to take the motions, but I leave it to the teams to figure out which you're presenting first.
Good morning, Mr. Chairman and Commissioners. Today, staff is recommending that the Commission approve for publication in the Federal Register a proposed rulemaking that would establish a schedule to phase in transaction compliance with the new clearing requirement and the new trade execution requirement, provided for under Section 723 of the Dodd-Frank Act. The compliance schedules proposed in this rulemaking are informed by public comments received in connection with a May 2011 roundtable held jointly by the Commission and the Securities and Exchange Commission to consider issues and concepts regarding the implementation of the Dodd-Frank Act. One of the key themes to emerge from the comments received by the Commission is that some market participants may require more time to ensure their swap transactions comply with the new clearing and trade execution requirements. Upon careful consideration of these comments, the proposal before you provides relief in the form of additional time for compliance with these requirements. This relief is intended to facilitate the transition to the new regulatory regime established by the Dodd-Frank Act in an orderly manner that does not unduly disrupt markets and transactions. The clearing requirement makes it unlawful for any person to engage in a swap that is required to be cleared unless that person submits the swap for clearing to a derivatives clearing organization. The Commission is required to determine whether a swap is required to be cleared pursuant to either a Commission-initiated review or pursuant to a submission from a derivatives clearing organization. The trade execution requirement requires that the execution of all swaps subject to a clearing mandate occur on a designated contract market or a swap execution facility, except where no DCM or SEF makes the swap available for trading or the swap is subject to a clearing exception. Under the proposed rule, the clearing and trade requirements would be phased in based on the identity of the counterparties up to the swap. The proposed compliance schedules would not prohibit any type of market participant from voluntarily complying with the clearing or trading mandate sooner than the compliance deadline. Additionally, the proposed compliance schedules will be used only when the Commission believes that phasing is necessary based on a variety of factors, including a market participants' experience, resources, and whether or not they are a third-party subaccount. The triggering event for the proposed compliance schedule for the clearing requirement would be the Commission's issuance of a mandatory clearing determination. The proposed compliance schedules for the trade execution requirement will be triggered upon the latter of the applicable deadline established under the compliance schedule for the associated clearing mandate, or 30 days after the swap is made available for trading in either a SEF or a DCM. Under the proposed rule, there would be 3 phases for compliance with the clearing and trade execution requirements. In Phase 1, any swap between or among Category 1 entities and their counterparties would be required to comply with a mandatory clearing requirement within the first 90 days after the Commission issues any mandatory clearing determination. Category 1 entities include swap dealers, security-based swap dealers, major swap participants, or active funds. The proposal defines an active fund as any private fund as defined by the Investment Advisors Act that is not a third-party subaccount and that executes 20 or more swaps per month based on a 12-month trailing average. The proposal provides these market participants with 90 days to come into compliance based on their level of swap activity, market experience, and resources. In Phase 2, a swap transaction between or among Category 2 entities and their counterparties would be required to comply with the mandatory clearing requirement within 180 days after the Commission issues a mandatory clearing determination. Category 2 entities include commodity pools, private funds other than active funds, employee benefit plans, or persons predominantly engaged in activities that are in the business of banking or in activities that are of a financial nature, provided that the entity is not a third-party subaccount. The proposal provides these market participants with 180 days, since these market participants will not be required to register with the Commission and may be less experienced or less frequent users of the swap markets than those in Category 1. In Phase 3, the proposal would phase in compliance for all other swap transactions, including those involving third-party subaccounts, and those not accepted from the mandatory clearing requirement within 270 days after the Commission issues a clearing requirement. Third-party subaccounts are defined to include those parties that may have numerous accounts to bring into compliance. The proposal provides these market participants with 270 days to bring their swaps into compliance because they may need additional time to document, coordinate, and manage numerous accounts. That concludes my remarks. I'm happy to answer any questions.
Thank you very much. The Chair will now entertain a motion to accept the staff recommendation concerning this proposed rule.
So moved.
Second.
I support the proposed rule to establish schedules for phasing of compliance with clearing and trade execution. I just want to ask some questions which may be outside of the proposal itself, but for Ananda and the clearing staff. Ananda, where do we stand, and maybe to the extent you can share with the public, again, nothing confidential, but where do we stand after September 26th as to the clearinghouses submitting swaps for this clearing determination? I sort of shared what I thought, but I'd be interested in what you're hearing and the public hearing, what you can tell us.
So far, we've reached out to the clearing organizations, and they're still thinking about it. So nobody's given me an answer as to when they're going to submit something. I think some of them may be waiting for the this commission and the SEC's action on the further definition of a swap. Right. So that's one of the comments that I got. Right. But I've not received any commitment.
So my thoughts that I shared publicly a half hour ago, that it would be later this fall at the earliest, and could well be the winter time before they officially submit it. We have to go through this 90-day process. You see that to be, it would be no sooner than that period, probably.
I don't think so. Yeah, I agree with you.
Sure. No, please. No, let's have a discussion.
I thought that in the rule that we did, that any swaps that were currently being cleared are deemed submitted.
They are deemed submitted. Last year we wrote to them and asked them to give us an extension. And
so that's an indefinite extension until we decide to lift it?
I think, or once the commission determines what a swap is.
And wouldn't it also be if they lift it?
Yeah, they can lift it.
Because they haven't lifted it,
no,
as I understand.
Well, I was just wondering, we asked them to do it, so would we be telling them to lift it, or
I assume it would be, you would be in discussions with.
Yeah, because the other thing we could also do is to, you've got swaps that they were being cleared pre-enactment, and then you've got swaps that have been cleared post-enactment. So instead of thinking of organizing work, instead of doing two separate things, why don't we do one thing at one time? So
I'm sorry, Commissioner I'm willing to
I thought there was a
the
60-day delay. Didn't we give them 60 days on pre-enactments?
No.
It's indefinite.
Yeah.
I mean, in essence, because they wrote us a letter. I mean, it's their letter to us asking for the delay.
That's right.
And it was a good thing they asked for it.
Maybe they were looking for our guidance.
Yeah. But where we are now is, though they could on September 26th, nobody has said they're going to do it on September 27th.
No.
Right.
Nobody's talking.
All right. And Deval, I think it would be helpful, just again to make sure I have the list right. So there would be no compliance mandated until we make this determination. I just want to make sure I have the list right.
Yes.
All right. So let's just go. And then we'd have to further define swap dealer, what we call entity definition, right?
Yes.
And swap, we have to further define swap as well, which we are calling product definitions.
Right.
And it's my hope that we take those up this fall. I mean, that's where we're sort of as a tentative basis, but we're working with the SEC, and a lot could happen that, to shift that. But we really heard loud from the market, let's get those in the early-ish phase. And then there's also two other rules that it's dependent upon. Is it segregation?
Yep, segregation and the end-user exception.
And the end-user exception, right. And the end-user exception so that market participants can know whether they're in or out.
Exactly.
And then segregation, it's just segregation for the cleared swaps.
Yes.
Right. All right. And in terms of Commissioner Amalia's question about when's the starting date, when's the end date, I think that the market will take some comfort from this. I mean, they'll see that there's at least 4 substantial and important rules that we have to complete, and we have to go through a 90-day clearing determination process, which I frankly would anticipate those 4 substantial rules we would get done by the first quarter of next year. I mean, even though we might be calendaring them for this last quarter, that some of them might roll into the first quarter, the clearing determination, 90 days, is unlikely to start until later this year. Now, I mean, again, the clearinghouses can knock on our door sooner, but so I think, Commissioner Malia, the likely earliest starting date is about 6 months from now, and could be later. I mean, your estimate is you think it could be the third quarter. I'm saying maybe it's as early as the second quarter. Is that how I understood your comment?
Yeah. Yes, as a guess, I said is around the third quarter was probably my best guess at this point.
Yeah, and I'm saying the earliest is probably the second quarter, the end of the second quarter, because we'd give them 3 months from the determination.
I think my exact statement was around the third quarter, so
Okay.
I think we're both in the same spot.
Yeah, yeah. And there's a lot that's beyond our control. It's the clearinghouses as well. Dan?
Yeah, I just wanted to make clear, I think it was implicit in some of the answers and in the questions, I just want to make sure it's clear on the record that the completion of those other rulemaking swap dealer definitions, those definitional rulemakings are not a prerequisite to the making of the determination of whether a swap should be cleared, but it is the prerequisite, as Deval has explained before, the actual compliance schedule kicks into effect.
I understand that there's no teeth before that time. And then, Deval, one other thing, or if there's anybody that wants to address this, the first category, second category, and third category, which I think is a good setting, swap dealers and active funds in the first category, and then other financials get 6 months, and then the people that are managing a lot of pension money, we call it sub-accounts, but I call it pension money, is the last category. But what if a pension account or a bank or insurance company wanted to clear earlier? What do we say about that? I'm interested in that, and then I'll turn to Commissioner Dunn for his questions.
Nobody would be prohibited from complying, in advance of when they're required to comply with the clearing requirement. And in fact, we've worded the regulation so that the Category 1 entities or 2 entities couldn't refuse, to clear those transactions. So nothing would prohibit them from voluntarily complying, and they should be able to do that ahead of time.
So if a middle market insurance company or an asset manager of some sort said, no, I want to get, in essence, the benefits of clearing, and that's their commercial desire, the dealer under this proposal would need to facilitate that, is what you're saying?
Yes.
Okay. Thank you. Commissioner Dunn.
Thank you, Mr. Chairman. Deval, how did staff come up with those timelines, the 30, 90, 180, 270 days?
Well, we took into consideration a lot of the feedback we received during the roundtable and reviewed many comment letters. And one thing that became pretty apparent is that people were kind of all over the place. Some people thought they could comply pretty immediately. Some people thought they could comply within a couple of years. So we tried to take into consideration everyone's sort of input and thought 3, 6, and 9 would be a reasonable time for people to be able to comply.
Let me turn to Gary and Ananda on this broader questions. And does this schedule work for the industry? Can they meet it? What kind of unintended consequences do they might see on this schedule? And then the second part of that, can the SROs and the commission meet this schedule? Are we going to have the staff available? Are we able to make these determinations and recommendations to the commission during these time periods?
We think this is a reasonable schedule, especially given the categories. It's Category 1 is dealers, MSPs, and active funds, which we believe are people who already are clearing voluntarily or have the requisite amount of sophistication to be able to clear. The other consideration is, we wanted to make sure that we propose a schedule that would give this commission an opportunity to meet the G20 commitment that the U.S. government has committed to, which is the end of December. So the requirement to clear is not new. Dodd-Frank has been in existence since July of last year. Anybody who's participating in these markets would come and tell me that they don't understand what's going on. I would find that very difficult to believe. So I do realize that around the margins there's a question of who an end user is and who can take advantage of the exception. But again, you're not talking about an unsophisticated person who's not a participant in the markets. The other point I want to make is if you're already trading swaps, there is a certain amount of sophistication involved in trading swaps. I don't trade swaps, well, not that I'm allowed to do so, but the average person in the street is not a participant in the swap market. So maybe I'm being a bit too tough, but this is the law. We're required to comply with the law. So I think it's a reasonable schedule, but we'll wait and see what the comments are. And as far as staff is concerned, that's always, as you know, Commissioner Dunn, that's always the unknown factor. We believe we have the staff right now. If you ask me, do I have enough staff to make sure this is done? I've told you from the beginning, the answer is no. I'm hoping that we will get the 2012 appropriation as the President has asked for. But if we don't get it, then it's a matter of deciding where to prioritize staff resources. It's not a satisfactory answer, but that's the only one I can give it to you. So.
I agree with Ananda. I think that there's enough time. I think the SROs can do it. I think the clearinghouses can do it. I think the documentation packages that the clearing members have to get out to the buy side and negotiate all that can take varying amounts of time to get things done, but there's a lot of time being given here. And so I think it's on the documentation side and dealing with the buy side and getting them all on board. That is only now in the marketplace starting to happen. And getting that out, negotiating it, getting it in place will take time, but more time is being given. So I'm hopeful that that will be sufficient.
For those that are voluntarily going ahead here, and I imagine what they're thinking is, well, this provides some certainty and it begins to give us some expertise in what's going on. How much are they in jeopardy of us saying, wait a minute, you're doing it wrong?
Meaning, how much are we in jeopardy of people?
Those that are going ahead and doing it.
Yeah.
Is there a risk of us coming back and saying, wait a minute, we think this is wrong, you've got to go back and do something different?
That the schedule is wrong?
No, what we're allowing them to do.
Oh, I see. Meaning we're giving them too much?
Yes.
Is that? Huh? Well, I think that would be a good comment. If the majority of the comments are that, hey, you don't need the schedule because we're ready to go, then, I know, but nobody's ever told us. Well, I'm not aware that people have told us that we're going to, that they don't want the schedule. I mean, maybe I'm not understanding your question.
Not just the schedule, the actual process, the rules.
Sir, are you asking, so for instance, if people are going forward today ahead of us coming out with definitive answers, are they at risk? I would think not. No, I don't think so. No. I think that the rules are largely written around market practice in a lot of respects,
right.
and those who would be out there trying to put things in place now are likely not going to find surprises in terms of these kinds of requirements that we're talking about today.
Yeah, especially with the clearing requirement, I think it gives people time, but there might be some people who say, I'm ready. And, as Devalas pointed out, if a Category 2 person is ready to clear, then, the proposed rules make it clear that they cannot be stopped. So,
Commissioner Dunn, if I could add, too, one of the reasons that I've asked the staff to be prepared on the clearing rules early in the queue, relatively early in the queue. I think it'll probably be the rule that we take up next with position limits. Is that too will answer a lot of these remaining questions. Does a clearinghouse have to do 5-day margining or something other? And, all of the risk management questions that were embedded in those clearing rules. And hopefully in the next month or so, that will be out. And so, at least on the clearing side, I think. Commissioner Summers.
Thank you, Mr. Chairman. First of all, I just want to start with a general question about implementation, and so maybe it's better directed to Dan. It's not specific to either one of these proposals. The issues that we're dealing with today, both trading and clearing and documentation and margin, are very important. But is there a reason why we didn't deal with the host of other issues that also may be relying on a sequencing schedule?
It was really focused on these particular documentation requirements, taking these ones and not doing the others at this particular time.
During the roundtable, the concepts that we put out dealt with several other issues that I think at the time, at least, we felt may also be appropriate for sequencing, and that's market infrastructure, real-time reporting. And so how will we deal with those? Will we deal with the potential sequencing within those specific rulemakings, or are we going to do other implementation plans?
Yeah, I'm not able to.
Let me try to answer it and have a discussion. I think the real reason is, just as we did with swap data repositories and what we hope to do in the clearing rule, is that on each of the platforms we've gotten a lot of input, and input from commissioners as well, as to the sequencing within that rule, the provisional registration, and then how long to the final registration and so forth. So I think it would be in the platforms and the broad 4S requirements within those rules. So in essence, even in documentation, there's a part of it that's not taken up in this rule. I don't want to make it sound like this is even narrower, but the swap dealer themselves have to have policies and procedures in place. Now, we could say that's 2 months later or 3 months or 4. We'll have to pick some time. These rules speak to any time that registered entity or registrant is interfacing with somebody outside. So as it relates to the 15 or 20 clearinghouses, they'll look to what we take up in a few weeks' time on the clearing rule. Similarly, on the swap execution facilities, though, we probably won't take that rule up until after the first of the year.
Will there eventually be a comprehensive plan that shows which ones you have to comply with when, and a comprehensive view of all of this?
Well, I think for market participants, this really does speak to that. If you're a hedge fund or an insurance company or even somebody else, this does that. For the individual platforms, as we did in the swap data repository rule, I mean, the handful of SDRs will know how they have to comply. The clearinghouses hopefully will in a few weeks when we address that rule. We could then stitch it together and put something there, but I think each of the platforms, the main rules for the platforms is when do you have to have your policies and procedures in place and be open for business voluntarily. This is dealing with the stuff that interfaces with the thousands of market participants.
Okay, I think I understand that that's no. Okay, so specific to this proposal, my questions are all with regard to the made available for trading. So footnote 35 in particular says that this rulemaking does not address the manner in which it may be determined or established that a DCM or a CEF has made a swap available for trading. So if we're not going to address it, what do we expect to happen? Anybody can make that determination whenever they feel like it.
This is an issue I think DMO staff is currently considering, since the purpose of this rulemaking was not substantive and just for the purposes of providing a compliance schedule. We didn't touch on that, but I understand staff is currently considering that issue.
Yeah, that's correct. And as you know, we did get a lot of comments related to that in connection with the CEF proposed rulemaking. So it's something that staff is considering, but is not part of this, which is really a compliance implementation proposal.
Right, but if we're going to try to, I guess, on the same sort of theme, deal with it comprehensively and not narrowly in the DCM rulemaking to apply to DCMs or narrowly in the CEF to apply broadly, where else will we put this? Because the process for mandatory clearing we've already done.
That's something to be determined. As I mentioned, we did get a lot of comments on this in connection with the CEF rulemaking. To some extent, some of those issues were addressed there. But that's something ultimately for the Commission to decide whether it's incorporated with one of the other final rulemakings or done separately.
Okay, thank you.
Thank you, Commissioner Summers. Commissioner Chilton.
Well, I think I just want to make a comment about what Commissioner Dunn was talking about if somebody goes forward ahead of when we're actually requiring it. And similar to what I was talking about earlier about how I think these rules, if we get them correct, can actually sort of fuel inject economic activity. I don't want to give away anything that people have told me and maybe my colleagues in confidence, but there are folks in several areas that I've talked with that are moving forward in this area. They're preparing to either do something ahead of when we are requiring it, and I'm not saying specific to these proposals, but there are areas, or immediately on day one trying to seek the competitive advantage. So, I don't think we want to, discourage that when people can see something coming and know what they're going to do. And I think we should not only not discourage it, I think we should value what they may be doing ahead of time that is right. When we talk about, CEFs, and we look at how they're going to operate, we should look at what is out there now that the private industry is doing right. We talk a lot about, and I've talked a lot about, what's gone wrong in this OTC area, but there are some things that have gone very right. And so I just want to make that point, Mike. It was following up on your comment. Now, on the issue that Commissioner Summers is talking about, this available for trading, I mean, if there's a determination that something needs to be cleared, but nobody offers it for trading, then it doesn't trade, right?
Yes.
I mean, that's the law.
It doesn't trade on a platform.
Yeah.
It'll trade bilaterally.
Will it trade bilaterally?
Yeah, because so the presumption is the Commission has made a clearing determination, but however it is determined what makes available for trading, let's say that we all agree what that means, and you cannot find it on a DCM or you cannot find it on a CEF, then the way I look at it, it'll trade bilaterally, but it's got to be cleared.
It's got to be cleared.
Yeah, got to be cleared.
That was my point.
Yeah, got to be cleared.
If a determination is made,
yeah,
but it's important enough that it has to be cleared.
And the assumption is there's a
it's
DCO.
Got to be cleared.
Yeah, there's a DCO.
It may not be offered on an exchange.
Right. Yeah.
So there could be a bilat, but even the bilats
got to be cleared.
Got to be cleared.
Correct.
I mean, that was the whole point of the law.
Yes.
So, okay. Did you want to say anything?
No, I was just, the use of the term bilateral, sometimes people think of as not cleared, so that was the confusion I was having. But you meant cleared
Cleared but traded.
But maybe transacted over between two parties, not in some central way.
Correct. But yeah, the clearing determination doesn't go away.
Yeah.
So it might be entered into bilaterally and then given up for clearing, right? So they entered into the trade and they give it up for clearing. You didn't have a SEF or a platform in the middle of
As
trading.
part of the market does today.
That's right. And also, Commissioner Till, I agree with you. I don't think there's anything in what we're proposing that would stop somebody from clearing, for example. So if somebody wants to clear right now, we would encourage that, and they would do that.
And how they're doing it might be educational for us.
Yes, absolutely.
Thank you.
Thank you, Commissioner Chilton. Commissioner Mayo.
Let me just build on. I'm thinking of Clearport right now. What happens with Clearport? It's cleared. It is made available for trading. What happens to those contracts?
From a clearing perspective, or from what perspective? I'm sorry.
Either made available for trading, or we're going to make a separate determination, or what happens to those products when we make this determination and 90 days later they have to be?
So let's say the Commission makes a determination that the suite of products has to be cleared. So which means everybody is obliged to clear, dealer, MSP, financial entity, must clear it.
And they're being cleared today.
And they're being cleared today. So it'll just be an imprimatur, so if I can use that term, that it has to be cleared. Right now, clearing is almost voluntary.
And the exchange trading requirement? It must be traded?
It must be traded unless no CEF or DCM quote makes it available for trading. And so the question is, what satisfies that condition?
I get to ask the question. You're supposed to answer them.
And that will be determined, as Rick said. The staff is working on the answer to that question, or recommended for the Commission's considerations, what that would be. But it won't be determined here. That'll be determined elsewhere. And part of the recommendation is where elsewhere, and how elsewhere.
We're dying to know. Commissioner Chilton, I completely agree with you on the first mover advantage. The CEFs have consistently told us, get out of the way. We're ready to go. We're trading today. Let it happen. And they want to know when is day one. And I hope we can do more to provide and tell them when day one is. We want to encourage that. So I agree with you. I think there's a lot that, especially on the technology exchange trading front, that's very exciting going on right now, and a lot of great promising companies. Let me ask the team, builds on Commissioner Dunn's question, a little bit on the cost-benefit analysis. What efforts did the team make to quantify the cost of implementation for either of these proposals? And based on the schedules outlined, we obviously heard from different entities that said, some of the Vanguard and Fidelity, some of these retirement funds that said, hey, we need 18 to 24 months is kind of what I've heard. We're telling them, you get 270. What are the consequences of that, and what did we estimate in our cost-benefit analysis of accelerating that date to make them comply with it sooner when they said they had this year-and-a-half requirement that they thought they needed to comply?
Staff from OCE that we worked with on this consulted with several academics, market participants, and industry groups when helping with the cost-benefit analysis. In terms of efforts to quantify, we really couldn't find any sort of data that we thought would be useful. We've asked several questions on the cost-benefit analysis and are open to public comment and suggestions going forward, and open to reconsidering the cost-benefit issues.
Commissioner O'Malley, I just wanted to add to it that the proposals take a perspective that the statute normally would require under Section 754 compliance within 60 days of the effective date of any of these substantive requirements. These proposals are adding additional time. And so in that respect, they are entirely beneficial. And the proposals are also compliance schedules. They don't consider the substantive underlying requirements that the market participants are saying they need additional time for. So in some respects, the compliance schedules themselves don't impose costs. And we look forward to comment on that approach, but just wanted to add that. Thank you.
Sounds like creative lawyering to me, but we'll move on. What process or guidance has the Commission outlined to let market participants know when the Commission will incorporate by reference this implementation proposal and when it will not? Specifically from the release, page 22, which I raised in my statement, quote, when issuing a mandatory clearing determination, the Commission would set an effective date by which all market participants would have to comply. In other words, the proposed compliance schedules would be used only when the Commission believes phasing is necessary based on the considerations outlined in the release. What's the standard? What date are we dealing with here?
So in writing the rule this way, we wanted to afford the Commission a certain amount of flexibility in the future. Our anticipation, we anticipate that because of the considerations we outlined in the proposed rulemaking, we will most likely be using the proposed schedule. But if the factors, if people have sufficient experience, if the cost aren't as much of an issue in the future, we're hoping that the staff in DCIO has the opportunity to kind of make those determinations if circumstances change.
Commissioner, can I, because your staff was very helpful, some of the edits that we incorporated even last night was very helpful. On this page 22, it says the Commission, which I support this because I think it addresses you, anticipates it will exercise its authority to trigger the phasing schedule each time it issues a mandatory clearing determination for a new group, category, type, or class of swap. So anytime we did it on a new, this was the language your staff helped on, group, category, type, or class of swap. And then it says under this approach, when it does a swap that is already in one of those groups, category, it's sort of, an additional interest rate swap, then it wouldn't necessarily use it. So, I think, anytime it would be a new group, class, or category, I think we're going to get comment on it, but I think it would be, you get phasing. If it's just sort of some fill-in swap, then, something else. I think that's what this means. Or does it?
Yeah. To give you an example of when we may not use this schedule, and you probably already noticed this, but if we had a credit default swap, a 5-year credit default swap, and then we decided, then we had a new 5-year credit default swap product based on a different index, that's something that, we might decide doesn't need to be, we don't need to use this schedule. I don't know if you have any further questions or that explains it.
No, I just think it warrants further clarification, and maybe by providing an example that would have been more helpful, but it is what it is. So I'm glad you were able to kind of clarify what you intend by that. I think Commissioner Summers raised a good question about what else should be in the implementation plan. And there are several things regarding swap deal or MSP, capital requirements, reporting and record keeping, daily trading records, business conduct standards, duties related to trading, risk management, information disclosure, conflicts of interest, antitrust, and the designation of a compliance officer. All of those would have been very helpful to have, I think, in this, to help understand how those are all going to be phased in, but I think we're going to do that in a different manner. So some of the questions that I had asked were not included. I'm going to include them. Hopefully that the market will market participants will comment on some of the questions I add in here. For whatever reason, they weren't included, but I'll just add them in again.
Okay. Thank you, Commissioner Amalia. And now I'm just trying to remember, am I going to take a vote on this one because it's got a motion, and then we'll do the next one? Or no?
I have just a real quick question, if you don't mind.
Yeah, please.
We've run across the issue on some other rules that we really maybe missed the mark on them, and we've questioned whether or not we need to repropose, or Mr. Berkovitz will tell us if you do that, you're going to need to repropose. And that's all fine. You know, we did a lot of these things very early. We're throwing things against the wall, as we talked about, Chairman's talked about. And but
I'd like to use another phrase. But
I don't even know if I was comfortable with yours earlier, actually. But
Promulgated regulations.
Yeah, we promulgated regulations. Thank you. You've been around a lot longer, Commissioner Dunn. So my question is there something that we can think about in this regard, maybe on the phasing, that if we got comments that maybe aren't comments we would expect, that would require us, if we wanted to change, to repropose? I mean, I know there are some extreme examples, Mr. Berkovitz, but I mean, that outside of what we think. But I just want to make sure we're not missing something easy. I support the proposal and everything. I just want to make sure that if some new group came in and they weren't mentioned, and we want to put them in this last phasing, that wouldn't require us somehow to repropose the rule. Or if everybody said we could do this all in 90 days, that we wouldn't have to repropose. We could get rid of the other categories. So it's a generic question, I suppose.
Yes, Commissioner Chilton. Not wanting to have trying to minimize those circumstances where we would have to say, no, you have to repropose. And as we've gained experience with these proposed rulemakings, we have paid very close attention to the questions we're asking in these, and to the extent we can anticipate possibilities where we might want to go in the future, to indicate questions and indicate what the commission alternatives and options the commission is also considering, and to include those in the questions. And there are questions in here related to what other potential requirements should be included within the phasing, or maybe possibly even expanded. Other documentation requirements, actually, that would be in the other rule. Are there other documentations that should be included, requirements that should be included within the schedule? Can some entities, we've asked specific questions about which entities are in which categories of these rules, and whether the time frames should be adjusted to give us the option, to the extent possible, of either lengthening or shortening the time frames, and to indicate that the commission is also considering options. Obviously, one never knows what other option there is that a commenter might provide until the commenter provides it, and then we would go through the evaluation. But we've tried to put commenters on notice wherever we can that we are considering variations on what we've proposed out there, to give the commission as much flexibility as we can foresee the commission might want to have, without going through yet another round of notice and comment. But then again, it will depend on specifics.
I would note, Commissioner Chilton, we have and we will probably repropose something along the line. We have done it. It was in an area in clearing called straight-through processing that Ananda and John Lawton presented a few weeks back. We are today further proposing some of our business conduct standards, and I mean, where the staff comes forward and the commissioners think it's appropriate, there's going to be, from time to time through this process, I guess as long as it's not a logical outgrowth of that which we have proposed. Do I get the right? That's
I've been
reading all these legal memos.
Yeah, I get that. My point was just, one, I wanted to make sure that we'd thought about all the outcomes, and the staff, as usual, has done a very good job of anticipating everything they can. You've got a tough job dealing with all of us. I appreciate that. But my point was that I think we don't have as much of a luxury as we may have had, last fall when we were doing some of these things. We're trying to get them all out that in meeting these sequencings and deadlines that I want to make sure that we're cognizant of that. So thank you very much.
So do I turn it to Mr. Staywick on this one, and then we'd go to the next one? Okay, Dave.
Commissioner O'Malley?
No.
Commissioner O'Malley, no. Commissioner Chilton?
Big yes.
Commissioner Chilton, aye. Commissioner Summers?
Yes.
Commissioner Summers, aye. Commissioner Dunn?
Aye.
Commissioner Dunn, aye. Mr. Chairman?
Aye.
Mr. Chairman, aye. Mr. Chairman, on this question, the yeas are 4, the nays are 1.
Thank you, Mr. Staywick. Thank you, my fellow commissioners and the team. I think you're all going to stay in place, right? And I gather, Mark, you're going to take the lead on this.
Good morning, Mr. Chairman and Commissioners. In Dodd-Frank Act Section 731, Congress amended Section 4S of the Commodity Exchange Act to require, among other things, the Commission to adopt rules governing documentation standards for swap dealers and major swap participants. Section 4S also requires the Commission to adopt rules establishing margin requirements for all registered swap dealers and major swap participants that are not banks. Pursuant to this statutory authority, on January 13th and April 28th, the Commission issued proposed regulations that, among other things, specify the documentation requirements for trading and margin. This further notice of proposed rulemaking, if so ordered, would be a continuation of those ongoing rulemakings by proposing schedules to phase in compliance with the previously proposed documentation requirements. The compliance schedules set out in this further notice are informed by public comments regarding the implementation of Dodd-Frank Act. One of the key themes to emerge from those comments is that many market participants, particularly those not required to register with the Commission, may need additional time to ensure that their swap transactions comply with the new documentation's requirements proposed. Upon careful consideration of these comments, the further notice before you provides relief in the form of additional time for market participants to comply with any documentation requirements the Commission may finalize under Part 23 of its regulations. Depending on the identity of the counterparty, swap dealers and major swap participants are afforded either 90, 180, or 270 days to bring their swap trading and margin documentation into compliance. This phasing accords by the category of counterparty, and it works as follows. In Category 1 are the swap dealers, major swap participants, and active funds. An active fund is a defined term used to capture any private fund as defined in the Investment Advisors Act that is not a third-party subaccount, but executes 20 or more swaps per month based on a trailing 12-month average. A third-party subaccount is also a defined term, and it's defined as a managed account that requires the approval of a beneficial owner to execute the necessary documentation. In the first of 3 phases of compliance, transactions with Category 1 entities, that is, transactions between swap dealers and major swap participants and Category 1 entities, would need to comply within 90 days of the publication of any final documentation and margin rules. In Category 2 are the commodity pools, private funds other than active funds, employee benefit plans, or persons predominantly engaged in the business of banking or finance under Section 4K of the Bank Holding Company Act. Also excluded from Category 2 are third-party subaccounts. Transactions between swap dealers, major swap participants, and Category 2 entities will be afforded 180 days from the publication of the final documentation and margin rules. Category 3 entities capture those third-party subaccounts. According to comments received, some entities, particularly large asset managers, may have hundreds or even thousands of such accounts to bring into compliance. Recognizing that even the most sophisticated asset managers have limited resources, this further notice provides relief in the form of 270 days to come into compliance. We also have a Category 4, which serves as a catch-all, intended to reach any person not otherwise included in Categories 1, 2, or 3. These persons would also be provided 270 days. Although this is a continuation of the previously mentioned Part 23 proposals, this further notice solicits only comments related to compliance schedules and the questions presented. The comments received and any compliance schedules that may be adopted will become part of any final trading and documentation rules the Commission may promulgate. Before concluding my remarks, I would like to thank Camden Nunnery of the Office of Chief Economist for his contributions to the proposed cost-benefit analysis. I would also like to thank Sarah Josephson of your office for her particularly valuable insights throughout this process. I'd be happy to respond to any questions. Thank you.
As I understand, Mark, this is a further proposal as it relates to the what we broadly call documentation or internal business conduct rules. Is that right?
That is correct.
And so if we run this, how long is the comment period?
45 days.
So if we run this comment period for 45 days, then summarize the comments, I guess, in November. That will be included in the administrative docket for those documentation rules that right now we're anticipating taking up after the first of the year.
That's correct. The proposal uses the same rulemaking identification numbers as the outstanding substantive proposals. So the comments will be consolidated within their respective dockets. That's correct.
Right. And one of the rules that we're looking at taking up later this fall, and I think the comment summaries around to the commissioners and so forth, is some of the business conduct, what we call external business conduct. It may have another term. I would just want to make sure that we can still do that and take that up and move effectively on external business conduct if appropriate.
Nothing in this would affect the ability to establish finalize those business conduct standards.
Okay. And we use the same 3, 6, and 9 month period, but we use some different preconditions. Could you just walk through again? I just want to make sure. I'll do. Tell me if I get it right. We have to further define swap dealer.
Correct.
We have to further define swap.
Correct.
All right. Now, what's the other things we have to?
We have to finalize the registration requirements.
All right. So that makes sense. So the swap dealers have to register.
Correct.
And we've calendared all 3 of those, hopefully sometime this fall, but again, we're human and it may be later.
Right. Then also the confirmation rulemaking, as well as the segregation rulemaking.
Which segregation? Segregation for uncleared swaps, right?
Correct.
So the segregation for uncleared swap and I think confirmation, I'm playing off of our dialogue, those right now I don't envision us getting to before the first of the year. Do I have those? Gary Barnett, is that correct on the confirmation?
That's right.
So we probably would be getting to segregation of uncleared swaps and confirmation sometime in the first quarter of next year. So to Commissioner O'Malley's question of when might this one start, again, I think this one starts probably at the earliest, end of February, end of March, because we have to get through the 5 further defining the various definitions, but the confirmation and the segregation. And of course, this is all at a docket that we probably would only consider in the first quarter as documentation. So I look at it, I know that there's a lot to plan, that this is more than 3, 6, and 9 months. It's probably 6 months before we finalize the 5 rules that need to be finalized before this documentation kicks in. So if I can do my math, and hopefully you won't say that it's just, what was the word you used about lawyering earlier? If you don't say, you won't say it again, but you don't say it about my accounting, is it 6 plus 3, which is 9 months for swap dealers and active managers of hedge funds to get ready for this. And you could add this roughly 6 months to the 6 and roughly the 6 to the 15. That at least had some influence on me as to when the Vanguards and Fidelities talked about 18 months, and I kind of looked at this and I said, this is kind of 15 months. This is towards the end of 2012 at least. It felt like it was in the same zip code. So, I mean, that's how I was thinking of it. But I do support this. I think it gives the market ample notice, whether it's 3, 6, or 9, or you allow me my accounting to say it's really 9 months 12 months and 15 months at least to plan and to start to work on this documentation, which is so critical. But I'm going to turn it to Commissioner Dunn.
You know, it's the chairman's prerogative to send things forward to the commission any time, so those schedules are whatever you say they're going to be.
Well, it's not entirely the case because it's also the staff, the Office of Chief Economist on the cost-benefit analysis, the really excellent input from the commissioner's offices, so it's a lot to be done here.
Well, now you're getting into the one area that I'm just going to ask about because I think the industry as a whole is going to go ahead and give us their take on this. But I would like to know, and I'd like to hear from the SRO, the NFA in this case, can we do the registration that is needed? And more importantly for us, are we ready, will we be ready to receive that documentation and approve that margining by the time these go into effect?
And can you just hold that question because I didn't follow Robert's rules. I need a motion to consider this recommendation from the staff on the documentation issue.
So move.
Second.
All right. Now, thank you.
Question.
And I think your question was, is the NFA ready to help with this process on this kind of time frame? And I think the indications are yes. But all still under discussion.
And are we prepared to accept that documentation? And probably gets to some of the concerns that Commissioner O'Malley has. Are we going to have the technology available?
We are mapping it all out right now, and we believe we will, but we're in the process of doing that.
Commissioner Dunn, can I ask you, are you envisioning that the documentation between a swap dealer and their counterparties finds their way here? Because I thought maybe Anand, I see, or Gary. We don't have to.
This is a requirement for the dealers, but eventually the NFA, as and when the 4S requirements come into place, the NFA will have to ascertain for itself that the registrants are in compliance with the 4S requirements. So I think in the proposal for registration, the Commission contemplated a provisional registration because it's all a matter of timing. If, for example, the entity definition and the registration rule are finalized ahead of the 4S requirements, then there will be provisional registration. And in our discussions with the NFA, the thinking was they'd start the registration process, and then as and when the 4S requirements are finalized and the effective date is given, the NFA will then determine compliance.
But I just wanted to make sure you didn't read any.
I don't see that, but I see it. The counterparties and even the third parties involved in there are going to have this documentation.
Right, but we don't get it.
We need to be prepared to review it, though.
Right. We need to be prepared. Somebody needs to be prepared to make sure that the dealers, because as Jim is correct, the obligation is on the registrants. Right? So somebody needs to be prepared to make sure that our registrants are in compliance with the CFTC's regulations. I'll be honest, unless we get money, we cannot do it ourselves. We have to get the NFA as our partners. But if we do get the money, then it'll be a big head start. But so the way I don't know what Gary thinks. I see it'll be a collaborative effort between us and the NFA, especially and one of the preconditions is that the Commission, I would recommend the Commission adopt as final the proposal that says all registrants, all SDs and MSPs have to be a member of at least one registered futures association, since there's just one. That will then make sure that the NFA has supervisory authority over dealers and MSPs who have to register because they are members. So.
Right, I agree with Ananda saying, but just for clarity's sake, and also what the chairman was alluding to, we've got a couple topics going on at the same time. So if we're talking about documentation for clearing documentation and the swap transactional kind of documentation, that is, clearing member, clearing house, buy side, so on and so forth. That's not with us. If we're talking about the registration process, identifying somebody as a swap dealer, then having to register, and how that process goes on, that's when the NFA discussion comes up and becomes most relevant, to where we are then interfacing how will that work and so on and so forth. And that's what I was referring to when I said we are working on that right now.
Thank you, Commissioner Dunn. And I look forward to continuing to hear more about how we're working with NFA, because I think we will need, just as we do in the futures world, to collaborate with them, and that's a collaboration that's gone on for decades. Commissioner Summers.
Thank you, Mr. Chairman. My questions are also with regard to documentation. In the proposals that we have done over the past year on the internal business conduct standards and specifically documentation, I think we have heard from a number of market participants that would be considered in Category 1 that these are very different from current market practices. So some of the things may have been developed around market practices, but certainly are wholesale different from what they do now. So in order for them to comply, how do we know that these extended deadlines are even appropriate when we have not finalized those documentation rules? I mean, at this point, we don't know what we're going to be requiring them to do in documentation. So I'm a little skeptical that we know how much time it's going to take them to comply when our proposals were very different from current market practices, and who knows what we'll end up finalizing.
Yeah, I'm aware of one topic involving give-up arrangements where there was a difference between where we are and where and some in the industry felt they wanted it to be, and so on. Aside from that, when I read what our proposed rules are requiring, I don't think there's that much difference. So I'm not sure that I think it's as broad as you're suggesting. But I'm just getting here, and I'll delve into it. But I'm aware of one significant issue, and otherwise I look at it, and I'm not foreseeing problems at all.
Okay, I'll show you the comments.
Okay,
after.
no, happy to look at it. Thank you.
Thank you, Commissioner Summers. Commissioner Chilton.
Thanks, Mr. Chairman. I mean, on that, the swaps world is, different than the futures world, so we have to do different documentation, I suppose. I wanted to just, when you were talking there about NFA, Ananda, and probably everybody in this room understands how this works, but for people who may be watching this now or later, I thought I'd do a little translation. The budget, and we didn't get everything we wanted to implement the bill, but as you said, we don't have the money currently to do this. The President proposed some user fees, and I reluctantly said I thought that was better user fees than not doing this. We need to implement this law, and so Congress would have to give us user fee authority. I'm not sure if that's really happening. I think when presidents of both parties propose user fees, that a lot of times not much happens on them, and it's really just sort of creative accounting at times. So when we're talking about using NFA to help do this participate in this regulatory role, and they have supervisory authority that we give to them, and that allows them to require registration. With the registration may come a charge. They will ask from the people who are registered to pay money. And that is how this oversight would be funded. So it's a user fee, but it's maybe not as transparent as everybody sees. So, Congress has to make the decision whether or not they want a user fee, whether or not it's from legislation, or whether or not it's this sort of, it's not really a backdoor approach, but it's a less transparent approach to getting, the law is the law. We're supposed to implement it. If we don't have the money, this is one way, at least, that we could implement it. So I just wanted to, again, people in this room may get a visual on all that, but when we're talking about, we'll just give it to NFA, that means more money for people who are registering. And my view has generally been that these are public markets and that it's a public good. These things affect the prices consumers pay for everything from milk to mortgages, and that there's a public interest in funding it. But we certainly need the regulations. So unless I've said anything incorrect, Ananda or Gary.
No, you're absolutely correct.
Okay, and I don't have a question. Thank you.
Thank you, Commissioner Chilton. Commissioner Amaya.
Maybe I could clarify a budget item in the user fee discussion. I think you're right. There's a trade-off here. The proposal in the president's budget, and both presidents, Bush and Obama, have proposed it. The difference between that and what the NFA provides for is a completely different universe. The budget proposal that we've considered would send all the money to Treasury. In fact, every dollar we charge the industry goes to Treasury. It doesn't stay here. Doesn't expand Ananda's team that he so richly deserves. It doesn't do any of that. It goes to balancing the budget or filling the hole in the deficit. At least the industry gets what they pay for with NFA. They sit on the board, they review the costs, they can see exactly what NFA spends money on, and they can understand what that cost is paid for. And I believe we address the transaction fee. Don't we, through seriatim?
All of their rules, yeah, you're correct, Commissioner.
So I would disagree. I think it's a more transparent process. The industry knows exactly what it's getting, and they can understand the transaction and the service that they're going to be benefiting. Mr. Barnett has to satisfy himself that the registration requirements and the collection of the swaps and everything else is what we need, and the industry needs to be satisfied they're getting what they want. But at least they get what they pay for, as opposed to the pig in the poke that is the federal budget.
Well, I don't disagree. Although of course it depends how they would write the user fee.
Congress could change the law.
They could say that it goes right to this. And again, my preference is they do it through an appropriation. But nobody should think that, at least for myself, that we're not doing this stuff. And somebody's going to pay for it. And that was my point.
Yeah. Well taken. One of the issues with entity-specific rules is the international coordination. And certainly the margin rule on extraterritoriality. When does it apply? Who does it apply? And some of we're beginning to receive some comments about, a bank located in a foreign jurisdiction trading with U.S. customers, and we're trying to sort out who the margin rules apply to. In developing this rule and the phasing of this rule for the implementation, did we speak to any international jurisdictions to think about their rulemaking process?
Not that I'm aware of.
Okay. Thank you.
Thank you, Commissioner Amaya. Is Commissioner Dunn, do we want to do a little dance for a bit? Or I'll ask a question or two. I'll come up with something. Commissioner Summers, please.
I have a question about the implementation plan that the SEC may be releasing, and if we know that the SEC's implementation plan, whether it will deal with these 4 specific issues or whether it will be more comprehensive. Because it would be weird if they're giving the exact same entities a lot longer or different considerations than what we're doing.
I don't know the answer to that question. We did share these proposals with the SEC. As far as I know, we haven't received any of their proposals yet.
Yeah, my understanding is they may not be as far along in their deliberations, though they have excellent staff. They have about twice the number of rules to take up, given all of their authorities in other areas. But I've certainly talked to the chairman about it, and I know staff's shared everything in our thinking. And we had the joint roundtable, of course, in May. Mr. Stawick.
Commissioner O'Malia?
No.
Commissioner O'Malia, no. Commissioner Chilton?
Aye.
Commissioner Chilton, aye. Commissioner Summers?
Aye.
Commissioner Summers, aye. Commissioner Dunn?
Aye.
Commissioner Dunn, aye. Mr. Chairman?
Aye.
Mr. Chairman, aye. Mr. Chairman, on this question, the yeas are 4, the nays are 1.
The ayes have it, and the staff recommendation is accepted. I thank Deval and Mark and everybody that worked on the teams, from the chief economist to the legal teams to the divisions, but also Dan, Rick, Ananda, and for your maiden voyage, Mr. Barnett. And I think that if people are, unless you feel like we need a break, we'll just call Jackie and her team up. So I think Jackie Mesa.
Chairman Gensler,
Oh, sure.
Do we need to vote on technical corrections? Harold mentioned.
Harold will look for unanimous consent on any technicals sending this to the Federal Register. Absent hearing any objection, yes. Thank you, Deval and Harold. Jackie Mesa, head of our Office of International Affairs, and Robert Rosenfeld and Aaron Miller are going to come up and talk about the IOSCO publication of principles for the regulation and supervision of commodity derivatives markets. And so why don't I turn it over to you, Jackie, and you could present this and the excellent work I know that you and Robert and Aaron have been doing overseas.
Thank you. Staff is recommending that the Commission authorize me, Jacqueline Mesa, Director of the Office of International Affairs, to not object to the IOSCO Organization of Security Commission's publication of the report on principles for the regulation and supervision of commodity derivatives markets. Before beginning, I would like to thank 2 people on my staff who have worked hard on this report. Robert Rosenfeld, sitting to my left, Deputy Director of the Office of International Affairs, who really had the laboring oar in this report, and Aaron Miller, an attorney in the Office of International Affairs and also a member of the task force. In my remarks, I will explain who developed this report, why IOSCO wanted this report drafted for delivery in September, the content of the report, our estimation of the most noteworthy principles, and the significance of these principles. This report was developed by the IOSCO Task Force on Commodity Futures Markets, which is co-chaired by the CFTC and the United Kingdom Financial Services Authority. In addition to the United States and the United Kingdom, 18 regulatory authorities from 14 jurisdictions participated in the task force. The report therefore draws on a broad range of regulatory experiences. IOSCO organized the task force in response to global concerns with respect to volatility and price increases in energy and agricultural commodity markets. The report before you today represents IOSCO's response to specific calls by the G20 leaders and finance ministers. In November 2010, the G20 leaders called for enhanced transparency in both cash and derivative markets and requested that IOSCO report its progress on this work to the Financial Stability Board. In April 2011, the G20 finance deputies asked IOSCO to finalize by September 2011 its recommendations on regulation and supervision in this area, and especially to address market abuses and manipulation, such as through position management powers, including the authority to set ex-ante position limits where appropriate, among other powers of intervention. IOSCO provided the FSB with an update of its work, and in April 2011, the FSB stated that it welcomed the ongoing work of the IOSCO on commodity futures markets and will consider next steps in this area in light of IOSCO's final report on commodity financial markets in September 2011. I've recounted this history to underline the importance that the international community attaches to this report. The report will create IOSCO principles for the regulation and supervision of commodity derivative markets in the following areas: contract design, which is focused on established design concepts for futures contracts. Surveillance, including the basic framework for surveillance, powers needed to access information for on-exchange, OTC, and cash market transactions. And the report emphasizes the importance of monitoring large positions. It also addresses disorderly markets, which sets out powers needed by market authorities to intervene in markets to address disorderly conditions. Enforcement and information sharing, which address the basic framework for successful enforcement programs, including needed powers. And finally, enhancing transparency to both public and regulators through publication of open interest according to certain categories of traders, and the reporting of OTC derivatives to trade repositories. In constructing these principles, we updated and added to original guidance that was given in 1997 in the Tokyo Communique, and that work was led by the US, the UK, and Japan. I'm going to briefly just highlight some of the more significant principles in the report. First, large trader reporting. For the first time, the international community is endorsing a system of large trader reporting as a mechanism to facilitate the monitoring of large positions on an aggregated basis. Second, a framework for addressing multi-market abusive trading. The report recognizes that a jurisdiction's surveillance and enforcement structure should actively look for and respond to trading abuses that involve futures, OTC derivatives, and cash markets. A theme throughout the report is surveillance cannot be one-dimensional, but must look at the trader's total activity. The principle on intervention of powers in the market. The report calls on market authorities to make credible use of their intervention powers to address disruptive conditions. I think this is important. For the first time, futures market authorities are endorsing on an international level that those intervention powers include, among other things, the power to set ex-ante position limits, particularly in the delivery month. And finally, commodity derivative market transparency. For the first time, the international community is endorsing the publication of a CFTC-like commitment of trader report. The principles themselves will set the standard for commodity derivative market supervision and regulation. In this sense, the principles will operate to harmonize international regulation of commodity derivatives markets. The principles establish a solid framework for fostering market integrity and strong surveillance and enforcement functions. More broadly, these principles reflect that IOSCO and the international community recognize how important derivative markets are to national economies, and that these markets deserve and require the international authorities to work together to raise global standards. I'm happy to answer any questions you may have about the report.
First, I think I'm supposed to entertain a motion to accept your recommendation that we authorize you, Jackie, to not object to this report at IOSCO.
So moved.
Second.
All right. I had to get that straight. First, let me do a big thanks to the staff, Jackie and Robert, of course, Aaron and everybody that's worked on it, but also to Commissioner Summers, who heads up our Global Markets Advisory Committee and tirelessly goes overseas to represent this commission at various IOSCO meetings. And I don't do that lightly. I think that this report and it being on the public agenda is important because it is a real sign of the harmonization that Commissioner Summers and Jackie and her team have been able to promote and accomplish. And I can't remember what section it is of Dodd-Frank, but I think, what was it, 727, I think, where it actually asks us to harmonize overseas. So this report, and Jackie went through the three areas that I thought were remarkable, but this report for the first time has an international body saying they'll be endorsing, using all sorts of words of diplomatese, but endorsing large trader reporting. Is that correct?
That's correct.
And we've benefited, and I think our markets have benefited from that large trader reporting for some number of decades. Secondly, this agency many years ago moved towards public transparency through what we call commitments of traders reports every Friday in the futures world. And this is an international body endorsing something similar. It's not identical words, but is that?
That's right.
And I think most importantly, for some of the deliberations that have been going on for the last 3 or 4 years around position limits, and Congress addressed it in 2008, and then again in Dodd-Frank and this commission's deliberations, this is an international body that appears on the precipice of saying something at least consistent with the authorities we have. I know they use terms like position management rather than position limits. But is that correct, Jackie?
That is correct.
And Congress mandated that we do everything we can, not just to harmonize, but in the position limit area, that I think they had an extra little bit of language that we should try to harmonize. So I thank Commissioner Summers and the staff for their work on getting us this close to a document that, roughly does that. I mean, I know there's a lot of diplomatic words and shall considers and may considers in here.
Yes, thank you. I just to add on to that a little bit, that this is an international document, and these are principles. It doesn't prescribe the means to achieve the principles, but as you stated, I think this goes a long way to sort of raising the standards on a global basis for derivative markets.
So I support this. I think this is really a very significant achievement of everybody that's worked on it, and I endorse it, and I hope that the IOSCO endorses it in a couple of weeks. Commissioner Dunn.
Thank you, Mr. Chairman. Jackie, let me thank you and your staff for all the hard work that you put into this and actually taking the lead in IOSCO and developing these principles. I'd be remiss if I didn't recognize our fellow Commissioner, Jill Summers, who has done such an outstanding job as our GMAC chair. It is delightful, Mr. Chairman, when I'm at international meetings to walk in and the amount of respect and deference they have to the Commission due to Jill's hard work and the ground that she has laid has just been magnificent. And I know she's worked very, very hard for us to achieve that level of deference and respect internationally, and especially in IOSCO. So, Jill, thank you for plowing all that heavy ground for us. I've just a couple of questions, Jackie, on this, because when you work internationally, it's always on a consensus type basis. And how do we go about to ensure that other countries are in fact going to adopt this, or how do they get prodded on? And I know IOSCO does assessments, and it's late in their assessment period. So how do you envision this document, these 22 different principles and these broad areas that you've outlined, being adopted, or other countries being prodded to?
I think what's unique about this report is many of the reports that IOSCO issues, they don't call the recommendations principles. They call them just recommendations. But here we were very deliberate in calling them principles, and so that later they could be used to actually assess jurisdictions against the principles. In order for them to be assessed, as you referred to, I think, by the IMF and World Bank, doing a formal assessment process, they have to be adopted by the entire IOSCO membership and adopted into their principal regime. That process took place sort of last year to update the principles, and I don't envision that happening soon. That said, there are other ways to kind of assess a jurisdiction against this report, and IOSCO is considering them now. One way is for the task force to do sort of a self-assessment of task force members and whether they are complying with the principles or what they're doing to come up to compliance with the principles. And we will probably recommend that as a next step for the task force. And in addition, of course, authorities can always do self-assessments against the principles. And this report was definitely intended to have that kind of assessment take place.
That begs the question, as we're going through the process here of adopting our regulations for Dodd-Frank, are we in general compliance?
We believe we're in general compliance. We worked very closely with the other divisions, specifically Division of Market Oversight and DCIO and OGC, in developing this report, and enforcement, of course, and making sure that what we are stating in the report is really the best practices and rules and regulations that we're applying here. We tried to make them as current as possible so they reflect our current way we do surveillance and enforcement, et cetera. But we believe we're in compliance.
The report talks about in the compliance that it's market authorities and I guess SROs that are really going to be responsible for the implementation aspect. How do we stand here?
That's a good point. The term throughout the report is market authorities, and market authority is defined as the regulator, the exchange, or the SRO. So in many of these principles, particularly on surveillance, it really is an exchange duty in the U.S., but the idea was not to dictate in the report, again, the market structure that the nation may use, but yet to say whoever is delegated or whoever has this responsibility, this is the goal we want achieved.
Once again, let me thank you and your staff for going forward with this, and Commissioner Summers, thank you.
Thank you, Commissioner Dunn. I'm just going to correct, I had cited the wrong statute number, but it was 752 is on international harmonization. So, Commissioner Summers.
Thank you, Mr. Chairman, and thank you both, Commissioner Dunn and Chairman Gensler, for your kind words, but really the compliments all rest with Jackie and her staff for all the hard work that you have done, and Robert in putting this report and the previous reports that this task force has put together. I mean, when the task force was created in 2008, you were under a very tight deadline in getting a report out to the public with regard to the regulation of commodity markets. And as the name reflects, IOSCO is an organization of securities commissions. So from my perspective, it is very significant to even have a task force on commodity derivatives within IOSCO, and a giant step forward for us as a leader in this area to be putting out reports with regard to commodity derivatives. So thank you for everything you've done.
Thank you.
Not just on this, but on the previous reports, and I guess it leads into my question. You have tackled other issue areas in your previous reports, oil markets specifically in the past, and now this on principles for the commodity markets. What are the next steps for the task force, and are there other issue areas that you think need to be addressed?
The next steps somewhat may be determined by the FSB at their meeting on Monday. In their previous statements, they said that they will consider this report at their meeting in Monday, the steering group of the FSB, and consider what next steps need to take place. They may just endorse the report, but they may actually ask IOSCO to do more work in certain areas. But additionally, of course, the task force can come forward and recommend work to the IOSCO Technical Committee, of course, where you are a representative, and suggest further work in certain areas. I think some of the further work that the task force really wanted to do is to drill down on some of these principles, and so that there is a separate whole report on some of the issues in these in this document, and then to provide more guidance to the regulatory authorities. One area, for instance, was on the commitment of trader report, was to drill down further on how to do that, and hopefully in the to harmonize, so that when you're looking at one of these, we're defining terms in the same way. So that's probably where we may go next.
I think I don't have any other questions, but I think just generally to say that with regard to not only this task force, but also the IOSCO task force on OTC derivatives, you and your team have done an incredible job. And to tell the public that there's a report that's already done, a report that's out for consultation right now, I think, right? Still open for consultation.
That's right.
And another report to be done on OTC derivatives. So thank you for all of that work as well.
Thank you, and thank you for your support.
Thank you, Commissioner Summers. Commissioner Chilton.
I don't have any questions, but commend you for all your work and your team, and commend Commissioner Summers, too. And she really has been a leader on this. And I'm also going to say a nice word about other people, but I don't want to minimize the work that Jill's done, so I think it's been helpful. But, the chairman's been overseas. Commissioner Dunn's been to Birkenstock a couple of times, carrying the flag. Commissioner O'Malley was in London earlier this year. I was over there. I was in Brussels, and President Sarkozy was there, and he spoke eloquently on the need to move forward on these things. And I don't know they use the word unison, but together. And so President Fernandez of the Dominican Republic, his office has communicated with us on these issues too. And I think in general, like I said at my opening comments, that this should alleviate some concerns among people that there's going to be some tectonic plate shift up in the U.S. because droves of traders are going to move offshores. That there's been a few examples. I was trying to find it. I believe it's shout out to Cilla Brush. I think it's a Bloomberg story from April or May that talked about how Singapore was saying, well, we don't want to do limits, and I think those things actually are going to be short-lived. I think generally we're moving together as an international community. We're all going to have our own sovereign issues, but by and large we're moving together, and that the changes as we're primarily doing them together are going to actually make our markets more competitive. People are going to want the certitude of the markets that we have. So I commend you. I think this is a big step, and I'm glad we're moving forward with it. Thanks.
Thank you, Commissioner Chilton. I'm wondering whether Commissioner O'Malley is going to give a shout out to somebody else at the press table, but new standards.
I'm going to continue to rain praise on Commissioner Summers for her work, and obviously the work of the international team for their work. Frequently, since coming to the commission, I've gone to ask Commissioner Summers, how does this all fit together? What does IOSCO stand for? What does it do? How will it add value? How do we coordinate? And she's always been very generous with her time and explaining it to me. And as Jackie and Robert and the rest of the team, Aaron, have been very helpful in making sure we have to coordinate. But it has to be more than words. We can agree to principles, but it's going to get down to the nitty-gritty here when we are debating over what margins apply to which people. I think, Jackie, you just made a great point about large trader. What if we use different data? Commitment of trader reports. What if we're comparing apples to oranges? That's not helpful. And so the real work, and we're going to have to put Commissioner Summers back on the plane, Jackie and her team going back on the plane for these, no doubt, not very luxurious, all-day meetings, nonstop, hashing out words, trying to find accommodation internationally. The hard work is probably yet to begin. People asked about our rulemaking proposals. It was easy to put out the drafts. It's tougher to put out the finals, and that's kind of where we're into right now. And I have a handful of questions here I'd like to ask just to make sure I understand this process. This task force report seems to me caught partway between a futures regulation and a post-Dodd-Frank world. For example, we talk about trade repositories, position management, and broader manipulation authority. And I think you mentioned that or maybe Commissioner Summers mentioned that there's another report coming. How do these reports fit together, and how do we ensure that we're timely? Because even though our pace is becoming, or our order and implementation is becoming a little clear, it's still going to be a guessing game and a lot of variables at play here. How do we make sure that all of these pieces come together and we're submitting the relevant reports to the relevant people in relevant time frames? What's next?
there are a lot of work streams. I think maybe the best way to explain this is there's a lot of work streams going on internationally across the board, and I know Commissioner Summers was referring to the OTC derivatives task force that specifically is addressing issues in the OTC sphere. So they have a data report out right now, and they will issue one on general standards is the next one. So I think that is the task force, and that's the group that is really kind of, I would say, if you put it in these terms, Dodd-Frank oriented, but OTC oriented. And then this work and this report is primarily about on-exchange derivatives trading, although we did not want to close the door that some of the principles in here could be applied in the OTC space. They're instructive. We say they're instructive, but they're not in the same world as when we're trying to say these are the principles that you must have for the on-exchange trading. So I think taking in light all of those work streams, we try not to step on the toes of the separate work going on in the OTC sphere, which is why you see a mention of OTC derivatives, and it feeds in, of course, to some of these principles, but it is not really explicitly going in that space because you've got a lot of other work streams handling it. And I just want to mention one thing. You mentioned margin and coordination. On a global scale, there will be a group going forward to try to harmonize margin on a global basis. I think that's really important work. The Federal Reserve is participating, we're participating, the SEC is participating, then of course national regulators from all over the world.
What's the timetable on that?
They're going to have their first meeting, I think, in October. And then I don't know that because it's just going to be a first meeting, it's not determined yet the time frame of how long it will take or when the end date is.
What direction should the various Dodd-Frank rulemaking teams take from this document in developing our rules? Have you shared this with the various teams, and are they looking at it?
Mm-hmm. We shared it with all the division directors, of course, and many people downstream, because again, it doesn't necessarily directly address OTC derivatives, but the other work in IOSCO does. These documents aren't necessarily geared toward that and have not, I don't think, globally been shared with the teams, but I would have to check with the directors.
Okay. How will the task force members, the IOSCO task force members, commit to implement comparable regulations to avoid the extraterritorial disputes that we might be setting ourselves up for? And is there a process, I didn't see it in this document, but is there a process that you and your colleagues have committed to that?
Let me know if this answers your question, but I think it might relate to one that Commissioner Dunn asked, which is how do we know that people are actually going to implement these, and that's sort of the next step.
I'm less concerned whether they're going to implement them, because I think what they will do is we will, some will implement here and some will implement here, and we'll have agreement that we're within the principles, but closing this gap is going to be the challenge.
I think we should consider, I think there's several things. I think first we should consider this a first step. First you have to establish the principle. Second, IOSCO is a body that, and as many international organizations, that don't determine, again, the means to get to the final outcome, but just say these are the goals, and then let each regulatory jurisdiction decide how to get there. And that's precisely because of historic reasons, different legislatures. To determine the exact way to get to a certain principle on an international scale is fairly rare and not impossible. And in important areas, we are trying to do that.
Can you, since this is it's clearly a dual track, right? You've got IOSCO trying to coordinate everybody, but you've obviously got the five of us. You've got international bodies working on their own separate rules. Can you provide a quick update as to what the current EU reforms are, what the schedule looks like, and when we expect both EMIR and MiFID to meet the G20 deadlines?
I don't have the exact time frame,
we
but
seem
I
to be
can
suffering
give you
from that everywhere.
Yeah, I can give you a general view of where they are. So as of yesterday, they had began council negotiations. So that's the 27 member states in the European Union came together as a body to look at EMIR, which deals mainly with mandatory clearing and trading. And that legislation is still in peace. It was passed by the Parliament. But once the Council settles on a draft, there will be work together to come out with a final piece of legislation. And MiFID is supposed to be, the MiFID review is supposed to be proposed by the European Commission, I believe, next month.
Do we have an estimate on when that, because we have today we've spent a good portion of the day talking about our mandatory clearing and trading timelines. And apparently the chairman and I agree that around the third quarter is when this one comes home. Are they going to be around the third quarter?
Mandatory trading and clearing is in EMIR, and that I think will be finalized by the end of the year, and then implementing regulations by ESMA and the other authorities in Europe by sometime in 2012, with hope to meet the G20 deadline by the end of 2012. So on clearing and trading, I think, or clearing and reporting, I believe they're pretty much there. On MiFID, which handles separate issues regarding trading and some of the issues we talked about today, it's further down the time frame. Again, the EC first has to propose the legislation, which will be sometime before the end of the year. And then it goes through this Parliament, EU Parliament has to pass it, the Council has to pass it, and then they have to pass a common draft. So it's further down the line in 2012 and 13.
Now, I understand the SEC is working on a pretty extensive and detailed extraterritoriality proposal. I'm not aware of where ours stands. I know we've assembled a team, but I don't know how detailed and how specific it will be or how extensive it will be. Are you talking to the SEC? Are you in coordination with them?
We are talking with the SEC.
Okay.
I say we're doing it at the chairman level, the general counsel's level, the international. There's been a lot on the international. Of course, we have something, Commissioner Malia, they don't have is Section 722D. They didn't, and even to this day, they feel comfortable they didn't need a specific thing from Congress. But that Section 722D that we have, they don't have the parallel in Dodd-Frank. And so there's some differences there. And a lot of what we're discussing is the application of that Section 722D and seeking, putting out some guidance and getting notice and comment on that, okay, which is a little different than their world because they don't have the exact parallel.
Okay. Now, Jackie, you and I have talked about, obviously starting with when I first came on, we started talking about Pittsburgh, September 2010. The goal was to have, it was really a two-part mandate from the G20, is to improve our physical data on commodity markets, energy markets, and also financial reform. Now we're obviously well down the way with regard to financial reform, but we still seem to be lagging in terms of physical reporting of data. The Europeans, I think, probably did the right move into improve agriculture data, but the oil market data is woefully inadequate, especially non-OECD nations. I think obviously the growth in consumption is in non-developed nations by a long way, and so there's a lot of factors. And in fact, the FTC kind of confirmed that in their report that just came out this month, and I think this report would be very helpful to make sure that it really looks at kind of both the factors, the supply and demand factors, the physical data factors, the financial reforms. Can I ask you to make sure you get this to your IOSCO colleagues to make sure it's in future reports, this reference, because I know they do call all the economic analysis out there, and just to make sure that this report makes it in.
I'm happy to share that.
Thank you. Do you know if they're going to make any headway in improving compliance with reporting of physical data from all G20 nations?
There's a G20 group on oil market volatility that is working on just this issue. It's led by the French, and they've had several meetings, and it's to really assess jurisdictions and how they're reporting to the JODI initiative, which I know you're familiar with. And they have made progress. They actually have made progress with several of the countries. There are still countries that are out of compliance, and they're putting pressure on those countries to make progress.
Thank you. Good work on this report.
Thank you.
Thank you, Commissioner Amalia. Just before I ask Mr. Staywick to call the roll, I have a unanimous consent to note for the record that the Commission business required consideration of this matter with less than 7 days notice. Apparently we sunshined it was 6 days, but not hearing any objection, that's done in the record. Mr. Staywick.
Commissioner O'Malley?
Aye.
Commissioner O'Malley, aye. Commissioner Chilton?
Aye.
Commissioner Chilton, aye. Commissioner Summers?
Aye.
Commissioner Summers, aye. Commissioner Dunn?
Aye.
Commissioner Dunn, aye. Mr. Chairman?
Aye.
Mr. Chairman, aye. Mr. Chairman, on this question, the yeas are 5, the nays are 0.
With that, I guess, Ms. Mesa, you can have authority to not object to the publishing of this by IOSCO. I did the technical corrections, just looking. Our next scheduled meeting is September 22nd. I think the schedule after that is October 4th. I've already said what the next couple of things in the queue are. If we're ready, we'll go on the 22nd. If not, we'll probably go on the 4th. I mean, we'll just see how, these things that are in the queue continue to be reflecting the commissioner's comments back. So we, for the public, will only tell you on the 15th what we're doing on the 22nd, or even if we're meeting on the 22nd, I guess, just depending upon how these two ripen along the way. But we will put that on our website with 7 days' notice. And if there isn't any other commission business, I'd entertain a motion to adjourn, but I too want to thank you all before we adjourn because it's excellent, really excellent work. I think this is, of all the pieces that we've had, this one stands out because of the international coordination on commodities markets has not really been, as Commissioner Summers said, part of IOSCO in the past. So
moved.
Second.
All in favor? This meeting is adjourned.